I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I'm going to address an issue that is dealt with in my column appearing today on the ABI website. In short, the question is this: is an individual retirement account or a 401k that someone receives as part of a divorce settlement ever exempt if that person has to file bankruptcy? The Supreme Court has spoken generally to the topic in Clark versus Remaker in 2014. In that case, the Supreme Court held that an inherited IRA is not exempt because to be exempt, it has to be, quote, retirement funds, end quote. And that, in the view of the Supreme Court, means that the person who is claiming the exemption had to make the contributions that created those retirement accounts. But of course, when it comes to retirement accounts received as part of a divorce decree, it's a little bit different, but is it different enough from Clark versus Remaker? The leading authority so far on this issue came from the Eighth Circuit Bankruptcy Appellate Panel in 2018. In that case, the BAP ruled generally, if not per se, that retirement accounts received in divorce are never exempt. The issue went to the Eighth Circuit Court of Appeals, and just a few days ago, the appeals court didn't go that far. Rather, what the appeals court said was that based on the very peculiar facts of the case, the claimed exemption in these retirement funds was properly disallowed. So as I see it right now, we do not have any appellate authority on whether or not retirement accounts received in divorce are exempt. This is nonetheless an extremely important issue, and I certainly hope that when the cases come to courts in the future, they have some sympathy for spouses who receive retirement funds as part of a settlement, because you could conceive of cases where retirement funds may be practically everything that a divorced spouse has if he or she is forced into bankruptcy. I am not sure how the courts are going to rule on this. I think in a typical case, the spouse who goes bankrupt certainly does have the right to make some very appealing, shall we say, policy arguments. But it very well may be that the language of the statute is going to compel a result that no, those retirement funds cannot be claimed as exempt. Well, however the courts rule, I think it would be a very good idea for Congress to step in and amend either the Bankruptcy Code or the Internal Revenue Code and make some clear rules where people could effectively exempt retirement funds if they end up in bankruptcy. This is really important because, as I said, there are going to be a lot of folks out there who are not going to have anything else in the way of substantial assets other than perhaps meager Social Security if they're forced into bankruptcy. As I said, I am Bill Rochelle, Editor-at-Large for ABI. I will return same time next week with something interesting or important in the world of bankruptcy law. Thank you and good day.